Okay, we're ready to go.
No, David DeWitt's wearing the.
We wrote, we have to.
What?
No, this is the question you.
Oh, okay, something else.
Yeah, so.
On behalf of the League of Women Voters in the Athens County Public Library, I'm pleased to welcome you to this first in our spring forums of candidates, in this case for Common Pleas Judge of Athens County. I'm Ed Baum and I coordinate the forums. Once I get out of the way, they can really go. Let me bring your attention, although I think most people have seen this document. The canon of judicial conduct says that judge candidates may not comment on current cases or cases that are likely to become current cases. They can talk about their background, their experience, and the sheet that you have indicates some things you can ask them about their philosophy. But I just point out that they can't make any statement that would reasonably be expected to affect the outcome or impair the fairness of a matter pending or impending in any court or likely to come before the court in the near future. You can't ever tell about the far future. So, with that, we have a couple of housekeeping things to get done. I would like to introduce Mary Costello, who will say a couple words on the League.
Welcome. Glad to see you here this evening. I'm co-president of the League of Women Voters of Athens County with Ellsworth Holden. You're here, you know about me probably, but I just want to remind you that the League of Women Voters is a nonpartisan organization committed to promoting an informed electorate. Our local league is primarily involved in voter services, so our members organize the forums, as Ed said, and we also put out the voter guide, which appeared in the messenger today. In case you missed it, it is in the messenger today. League is also involved in issues of importance and concern to the community, and we have on occasion here in Athens co-sponsored a town hall meeting or a symposium or something on an issue of interest to the community. So we do that too. Again, in the interest of informing the electorate so that all of us can be informed voters. We encourage all Athens County members to consider membership, and all Athens County residents to consider membership in the League of Women Voters. We would welcome you. If any of you here tonight are interested, you can see me. I'll have some information for you. And one other thing I wanted to mention is we do have a website. So if you didn't happen to get the messenger, so you didn't happen to get the voter guide, our website is athensleagueofwomenvoters.org. It's up here on our banner. So again, welcome to everyone this evening.
Mary's doing double duty. She's also the timekeeper for this evening. I'd also like to introduce Linda Parsons and Beverly Flanagan. Their role is to look at the questions to make sure that the question that's already been asked isn't repeated again, and that the questions meet the guidelines both of the Judicial Code of Conduct and being able to be answered by all candidates. We have in the back Mary Lee Powell, who's at the door, who greeted you when you came in, and her second role is when you have a question, you write it down on the piece of paper, raise it up, she will come get it and bring it to the reviewers. We have our moderator, Ellsworth Holden, who I'm very pleased to give the gavel, as it were, to.
Thank you very much. I trust this is working, or let me know, because I'm a user, not a technician. And just a moment ago, I was told that this is being taped and recorded tonight, and on the City of Athens website, it's likely to be available within about 24 hours, tomorrow evening, probably. So feel free to let those know who weren't here, or go see it again yourself. And our thanks to the staff doing that. Okay, welcome to the Common Pleas Judge Democratic Candidate Forum, sponsored by the Athens Public Library and the Athens County League of Women Voters. And this is an important event in our attempt to help develop and nurture an informed electorate in our county. Tonight, we'll hear from 3 candidates, and the order in which they will make their presentations a bit Todd Grace, Pat Lang, and William Biddlestone. And first, though, let me review the ground rules for the evening. The candidates have seen these ahead of time. Each candidate will have 3 minutes to make an opening and an introductory statement, and the order was determined by lot a little while ago. And so I think I mentioned the order of the names. And after that, we'll have candidates from the news media. Each one will ask one question, and then we will turn to you in the audience and invite you to submit questions. So I think I see paper and pencil, and so feel free to jot down some questions and just sort of wave a hand and someone will come by and collect it. We have the 2 reviewers over there to make sure you have something. Is it answerable by both people, and make it, and so on and so forth. Okay, and then with the questions, each candidate will have 1.5 minutes to respond to each questions, and in an order which will rotate, having been selected by a random process. Okay, we're hoping this evening to have a balanced and educational program, and when we get to the end, each candidate will have an opportunity for a 2-minute closing statement. And so, now why don't we start in with the opening statements, and Todd Grace, you're first.
Thank you. So I'm not really very frequently in front of a microphone this way. I hope everyone can hear me and that it's working for what's being recorded as well. I am Todd Grace, and I have been back in Athens County for a little over 12 years. My wife and I moved back to Athens County after we were up at the University of Michigan for law school, where I attended that university and graduated. We came back to Athens because this is where we wanted our family to live. We really like Athens. It's treated us very well. So we came back right after having Wesley, our oldest. We came back and I started practice. And I've been, for the last 12 years, a little over that, practicing through Grace and McGee Attorneys at Law. It's a great experience. I get to do a lot of different cases. I've been able to pick and choose the cases that I enjoy the most. And so I've been able to identify the types of cases I like. And what I have come to the conclusion of what I like to do is trial court work in Athens County. It is very well suited for my personality. Shortly after starting my practice, Bob Stewart was elected to the Common Pleas Court Juvenile Probate Division bench as a judge. He had been, for a very long time, the magistrate in that court, and he asked me to be the replacement because he could not fill both roles as the judge and the magistrate, so he asked me to take over that role. I've been doing that for a little over 11 years. This is a quasi-judicial role. It has judicial elements to it where I hear cases, I make decisions. Those decisions are not final until Bob Stewart signs them, and that's the primary distinction between a judge and a magistrate. This has also been a fantastic experience. It gave me a lot of an opportunity to decide what I enjoyed about the judiciary, whether or not it was the right role for me, and whether or not I had something to offer the county in this role. I found that I do. After that, I was also given an opportunity by Bill Grimm. Judge Grimm was elected to municipal court, and he contacted me about becoming one of his acting judges. I did this for 4 years. This is also a judicial role. It's a position where you make decisions, and unlike the magistrate position, there is no requirement for an additional signature. The acting judge, when he or she makes a decision, the case is done. It can be appealed just like any judge's opinion, but it does not have any other layer to it. These experiences have given me the opportunity to know that I enjoy doing this. These experiences have also been important for me to make a decision about whether or not I want to be a jurist. I do. I want to stay in Athens County at the trial court level because this is what I enjoy doing, and this is something I know I have a lot to offer the county. I hope that the voters agree, and I hope I get enough votes to be given this opportunity. Thank you.
Thank you. Next, we'll turn to Pat Lang.
Good evening, ladies and gentlemen. Tonight I'd like to have a conversation about ideas and a conversation about where we want our county and our judiciary to go over the course of the next 25 years. And let me start with a very specific example. We've all heard the old saying about how the gears of justice sometimes can grind slowly. And sometimes that's by design. Sometimes the pace of a court docket is determined in some measure by timetables required by the Supreme Court or by the judicial rules. Sometimes there's only so much that a local judge can do to help to speed up those gears and to administer justice in a swift, thorough, and constitutional way. However, I have talked to a lot of judges, a lot of attorneys, a lot of litigants, and a lot of counties out there, and I can tell you that there are a lot of ideas and a lot of practices in other counties, and I don't presume to know that all of them will work in Athens County. However, it is in that vein that the first act that I will take as elected judge is to establish a sort of operations efficiency task force. And what that will consist of is a broad section of stakeholders in our judicial system here in Athens County. That will include prosecutors, public defenders, attorneys, former judges, law enforcement, clerk's office personnel, and administrative staff. Now, the goal of this task force will be to find ways to identify areas where we can increase our efficiency of operations within the judicial system in Athens County, to speed up the process where we can, while still respecting the constitutional rights of the accused and the rights of everyone who comes before the court, including victims and including all litigants before the court. The charge of this task force will be to report back within 6 months with a list of recommendations. Now, regardless of who wins this election for judge, the Common Pleas Court in Athens County will be undergoing some of its most radical change in 25 years. We're going to have 2 fairly new judges joining the court. It's an exciting opportunity, not just to review where we have been, but to review our options for going forward and where we can move forward. So, and I want to make this clear that this is not a criticism of the current judge or of the current administrative staff that we have in the Common Pleas Courts. Judge Goldsberry is an outstanding judge. In fact, he'd probably be the first person that I would ask to be on this task force. But I think it's important to broaden the conversation about what we can do to best administer justice in this county in a fair and a thoughtful way. I don't pretend to have all of the answers. But I believe that I do have the right background to not only to operate a court, but to bring people together, to widen our perspective, and that's what I would intend to do as judge. Finally, I'd like to thank the League of Women Voters for hosting this forum this evening. I'd like to thank members of the media for being here. I'd also like to thank my wife, Jenny, who's in the back wearing purple there. She actually, I tried to talk her out of coming to this just because I've been to a lot of these forums as a member of the audience. Sometimes they can get a little heated, so I said, you know, you sure you want to come here? But she was convinced that she wanted to be here, so hopefully things won't get too ugly here tonight. And with that, I'd also like to thank my 2 other candidates here. These are 2 attorneys that I certainly hold in the highest esteem.
We've got to cut you off, I'm sorry.
Would make a fantastic judge. Thank you very much.
Thank you. It always helps if you have someone who edges over a little bit at the beginning, because then we get a gentle chance to say we're serious about the time. So with that, thank you, and we'll go to William Biddlestone.
I'm having technical problems. I pushed the wrong button. I'm sorry. I'm a user, not a...
You don't have a time limit, Mary.
Well, and he'll get his full time. Thank you.
Thank you. Good evening, and thank you, League of Women Voters, for hosting this forum. I'm Bill Biddlestone, and I want to tell you a little bit about myself. Later, I will explain why I believe this is important. I was raised in the suburbs of Cleveland. Throughout my childhood, my father encouraged me to become involved in the helping profession. My father was a doctor, my mother was a nurse. They were both involved in helping others. I was born with a vision problem and have been legally blind since birth. I have to say that I have overall lived a very fortunate life, but only my major limitation being my inability to drive a car. However, I've always strived to reach whatever potential I had, notwithstanding any physical limitations. I graduated from Ohio University with a bachelor's degree in social work. I obtained a job as vocational counselor with the Bureau of Vocational Rehabilitation. During those years, I worked with people who had disabling conditions who were striving to be successful. Many of them were, despite our society's overall lack of acceptance of difference in people. This was in the late 1970s. I believe now there's a greater acceptance of difference, although there is still a substantial way to go before we can say there is no discrimination. I became disillusioned with the bureaucracy and was accepted into law school in 1980. I continued working full-time and attended law school part-time. I graduated in 1984. At that time, I had a dream of helping people less fortunate than I navigate the through our legal system and life in general. I returned to Athens in 1989 to accept a position as an Athens city prosecutor. Although I had never dreamed of being a prosecutor, I felt this was an opportunity to continue to do my part in helping others, while giving me an opportunity to work a 40-hour work week so I could spend more time with my young children. During the next 14 years, I made every effort to follow the ethical code and to do my best to ensure that justice was the goal of any prosecution, not just conviction. I'm the proud parent of two wonderful and talented children, Bob and Jessica. They are now on their own pursuing advanced academic degrees. But as every parent in this room knows, raising children is an experience of many facets, with many ups and downs. Yet these experiences give one a perspective on life surpassed by no other. I've told you a little about my background because I believe it offers a little insight into how I would approach the duties of judge. The decisions judges make have a great impact on people's lives. I believe that I have a wealth of personal life experiences to help me make those difficult decisions, not only fairly and impartially, but with an understanding of the consequences to the individuals involved. We cannot divorce ourselves from our past experiences, but we can draw upon them for understanding. Thank you very much for your attention. I urge you to vote for experience, vote for Biddlestone on May 6th. Thank you.
My thanks to all three of you. And now let's turn to questions from the news media. And we have Evan Smith of the Athens News and Susan Tebben of the Athens Messenger. And Evan, your question, please.
Yes. Could you please explain what you feel makes your particular experience and qualifications for the position special? And more to the point, do you feel anything in your experience is lacking or will require on-the-job training or on-the-job learning?
Now, do you have the order in front of you, madam? Okay, good. I've got it. I just wanted to make sure you do. So the first question is the same order, and then you've got that for the others. So I should have clarified that beforehand. Why don't you read that question again, because I wanted to make sure they have the order of answering. Pardon me.
Could you please explain what you feel makes your particular experience and qualifications for the position special, and do you feel anything in your experience is lacking or will require on-the-job learning?
Todd.
Thank you. This is actually where I think the largest strength in my candidacy is my experience and my qualifications. I have already outlined that to some extent. Part of what I think is also important is the reason why someone chooses to be an acting judge and chooses to be a magistrate is that you're making a commitment to be part of the judiciary and to make these decisions, not necessarily based on what your preferences might be, but based on what the law requires and what the facts are in the case. I have done that. I have been doing that for the last 11 years. It is a challenge. It always takes learning on the job, no matter how long you've been doing it. And there are requirements every year that judges and acting judges and magistrates have to go through to make sure that they're maintaining their credentials. I've been doing that for the last 11 years. It's a great opportunity to meet new people who are in the judiciary, and it helps you to learn. And I look forward to continuing to learn throughout my entire career.
Thank you. Next, we'll turn to Pat.
All right. Thank you. I think to the question of experience, I think it's very important that we define it in the right way, and it has to be something more than just the number of years that you've been doing something. I mean, if that were the case, then we wouldn't really need elections. We could just find a person who has been practicing the longest and been a member of the bar for the longest time and just go ahead and make that person a judge. I do think that any judge needs to have a certain threshold of experience. I think that's very important. But I think the most important thing is not just what experiences you've had, but what judgment you've garnered as part of that experience, what judgment you've demonstrated throughout your experience, I think is the real key to having a good judge and someone with a good background to be on the court. In my background, I'm in my 7th year right now as the law director for the city of Athens. It's a great honor to serve in that capacity. Before that, I worked as an assistant county prosecutor doing felony crimes, felony prosecutions, and a number of other things for the county, handling appeals. and also had a private practice that was open in which I did work in several different areas of law. So I do think that well, frankly, I think all of us up here have experience, but in my own experience in particular, I think both having that experience of a job where you're in a courtroom each and every day as an assistant prosecutor, and then for the last 7 years being more in a managerial role, overseeing 3 full-time prosecutors for the city of Athens, being involved in those cases and managing and leading a staff. I would say that's primarily what I would think would be my strongest points there. Thank you.
Thank you. William?
Thank you. I have, as I've said a number of times, 29 years of experience as an attorney practicing in a variety of different forums. I was a prosecuting attorney for 8 years. I was a city prosecutor for 4 or 5 years. I've been in court, I can't even untold number of days in front of unknown number of judges. When I practiced in Cleveland for 5 years, there was 35 judges in the common pleas court. And I didn't practice in front of all of them, thank goodness, but quite a few of them. And you learn and see a different amount of styles and techniques. And you learn an understanding of the fairness of certain judges exhibit and other judges you really don't feel like you get a fair shake from. I think that kind of basically legal life experience is important in becoming a judge. I've never had any experience at all in being a judge or a magistrate or anything along those lines. However, I have been with judges, I don't know, most of my life it seems like, watching them act and seeing how they interpret the law and interpret things and treat litigants primarily. I have also been involved in a number of jury trials, a number of other bench trials and other trials where I've learned the rules of court well, the rules of evidence, and I think all those would lead to an easy transition for me to the position of judge. I agree with Mr. Grace in that this ongoing learning experience for all of us. We even have as attorneys continuing legal education requirements because we always have to try to keep up with the current trends. Thank you very much.
Thank you. And now for the next question, the order is going to be Pat, William, and Todd. Makes sense to all? You've all got that? Okay. Make sure ahead before we turn. Okay, Susan Tebben, Athens Messenger, with the question, please.
Is this on? Okay. Answering questions from the media is one of your favorite things, I'm sure. My question refers to House Bill 86, which regards sentencing guidelines. The legislation basically has defined what sentencing guidelines for what cases. I'm sure you guys know that. So I wanted to know your opinion on House Bill 86, which is rather controversial, and how it would affect your discretion as judge. Would you become judge?
Pat?
I think that's a great question. Unfortunately, I don't know how deeply I can delve into that, given that it is something that's currently pending and that may need to be enforced, by the courts. I will just speak generally to your question, if I may, just about sentencing guidelines in general. And we've kind of seen some ebb and flow over the years about where the legislature will give more or less discretion to a judge to sentence in an individual case. I think some of the ideas that have been talked about now, such as taking a lot more discretion away from judges, particularly when it comes to lower level felonies. So when you're talking about, not the most major crimes out there, but still serious crimes, and essentially taking away some of that discretion. You can kind of understand where the legislature is coming from on these things because, the simple fact is that our prisons are overcrowded. I think most everybody would agree with that. At the same time, there's not a big groundswell of support out there for the idea of raising taxes to build more prisons or do anything like that. So they're trying to find ways within, the current budgets to be able to handle the problem of crowded prisons. However, I guess I would come down mostly on the side of saying that if we have the right kinds of judges on the bench, then we would want to give them the discretion to be able to recognize within certain boundaries that cases are different, and that certain cases need, maybe more of a harsh outcome, for lack of a better word, and some cases are going to involve more of a human touch, more of a taking the circumstances of a particular case into account. So I guess that's probably as close as I can come to answering that question. Thank you.
Thank you, Pat. William, you're next.
Thank you. You have to look, I think, historically at this question. Back in 1996, a bill was passed called Senate Bill 2, which added the level of 5th-degree felony. Used to only be 4 felonies, then it went to be 5. Part of the intent of Senate Bill 2 was to reduce the increase in the growth of the prison populations by making a presumption of not going to prison for 4th and 5th-degree felonies and a presumption of going to prison for 1st and 2nd-degree felonies, the 1st and 2nd being the highest, most serious crimes. the Supreme Court, sometime in the late 90s or early 2000s, decided that it was unconstitutional for the legislature to dictate to the courts how to sentence in those circumstances. And those considerations that were required by the Senate bill were then struck down. I believe this House Bill 86 is an effort to reinstate those same guidelines they had before in a way that the Supreme Court can't find it unconstitutional. It does call for that only under very limited circumstances can low-level felonies be sent to prison. I think this is a very big concern that we have in our society because of the overcrowded prison conditions that we have, not only in Ohio, but throughout the country. And we have the most imprisoned people in the civilized world. I mean, it's really hard to imagine. But that's what I think is going on. They're trying to fix that error that was created by Senate Bill 2 back in '96 and reversed by the Supreme Court. Thank you.
Thank you, William. Todd.
Thank you. And thank you, Bill. He's covered most of the history of this, and that's actually a big part of what I was going to cover. Let me instead address one of the other issues, which was the feeling within the legislature and within the public that there was too much variety in sentencing, that some judges would be very harsh while other judges would be very lenient. And the sentiment behind some of these motions are to try to limit that and try to create some consistency. And what I will say about that is consistency is important. You need to have consistency in the sentencing, but it's something that's very difficult for it to be mandated through the legislature. It needs to come from within the judiciary as well. It needs to be based on the facts that come before you, the facts of the individual cases, as applied to the law, and then make consistent decisions so that people that come in know they will be treated with fairness, no matter what their background, no matter what they have in their history that is outside of those permissible guidelines within the sentencing. And I 100% agree that the history, they're trying to get around it.
Thank you. Well, our next question, or for our next one, we'll turn to a question submitted by you, members of our audience. And for this, the order is going to be William, Todd, and Pat. You've probably got in front of you, but we'll try to make sure that I don't surprise you in the order for a little while here. Okay, here's the question. How would you protect the legal rights of poor and low-income people?
Basically, there's rules about everything in our society. There's rules that judges have to follow regarding the appointment of counsel for indigent people, indigent persons. There are no allowance of indigent counsel for civil matters, only in criminal matters or in some serious custody disputes that would deprive a person of their rights. So I don't know the whole lot that a judge can actually do except to ensure that the form in which the people come is, the playing field is leveled off for people that can't afford counsel and have to appear pro se because of financial reasons or other reasons. I would certainly, I've been involved with the Southeast Ohio Legal Services for a number of years, working at their legal clinic, trying to help indigent people file lawsuits and pursue lawsuits, and I've done a lot of pro bono work in that area. And in my private practice, certainly I've represented a lot of clients that haven't been able to pay me what I thought was a fair amount. But anyhow, so I've done a lot of pro bono work that way too. I believe that, and I really haven't minded that because I think people need assistance in these areas so much. As a judge, I think you just have to ensure that the playing field is as level as you could possibly make it under the circumstances.
Thank you. Todd?
Thank you. So in my role as a magistrate, I have a lot of individuals who come before the court who are unrepresented. They're pro se litigants. And one of the factors that you have to take into consideration when working with those litigants is that they need a different approach. You need to take the time to understand where they're coming from. They won't use the language that an attorney will use, but they many times will have the same intent behind what they're saying. Taking that time, making sure to communicate with them, making sure to understand where they're coming from is extremely important from the judiciary. There will be pro se litigants in common pleas court, whether it's on an anti-stalking civil protection order or whether it's on another civil lawsuit where they weren't able to afford an attorney. They need to make sure, everybody needs to make sure that they are heard, that they are understood, and taking the time, having the ability to communicate effectively with people, regardless of whether or not they have an attorney there, is an extremely important part of the judiciary, and something that I have found a very real aptitude within my role as a magistrate.
Thank you. Pat?
I would agree with everything that's been said on this question and agree with Bill's point that there are some really good resources available within the community for indigent litigants, indigent defendants. Certainly the Public Defender's Office represents people in criminal matters. Southeast Ohio Legal Services is just an outstanding organization that does a lot of work to benefit litigants in the community. Of course, at OU you've got the Student Center for Legal Services, which also does some great work. I guess I'll also take this answer in just a little bit of a different direction to talk not only about the litigants themselves, not only the defendants themselves, perhaps in a criminal case, but to talk about the rights of indigents, really the rights of everybody who comes into a courtroom. And this may seem like kind of a minor issue, but I can tell you that I've seen some things in my time in a courtroom. I'm sure that my friends up here have as well. And that is dealing with an issue of, I guess, courthouse security to some extent. And what I mean by that is just looking at the way that we have a design of the courtroom, the way that we bring in defendants, the way that we bring in the accused. Oftentimes, we're bringing them right through the front doors, right by potential victims of crime, right by potential witnesses, sometimes within arm's length. Now, thank goodness we haven't had any serious. I've never seen any serious problems as a result of that. Certainly nothing violent. But I can tell you that in any kind of a new building, and what's happening in a lot of other courthouses, certainly what would happen in a federal courthouse, you would never have folks being that close to the victims or that close to potential witnesses. And so, again, it may seem like a minor issue, but it's the sort of thing that I think we need to be thinking about and the sort of thing that we can be looking at when we're thinking of ways to possibly make the system run more efficiently. Thank you.
Thank you, Pat. Okay, for the next question, the order's going to be Pat, Todd, and William, which you have in front of you, I think. So here's the question. Drug offenses are too prevalent. Jail sentences don't solve the problem. What do you propose?
I think this sort of gets back to the earlier question about discretion when it comes to sentencing and being able to understand that each case is different. And that in some cases, you're dealing with somebody, particularly in a drug case, who may be a major trafficker. There may be somebody who's bringing in, a great deal of drugs, a great quantity of drugs from outside of the area, and that you can't treat that case, the same as a case involving, not even necessarily just a case where involving the same crime, but if you're talking about a lower level distributor, or talking about, or you're dealing with the kind of case where you're dealing with somebody who needs help. And so I think that having that discretion on the bench is key. I think we've also got a lot of good resources within the community for addiction. Certainly in my time practicing at the county prosecutor's office, we had a lot of drug cases. In fact, probably half of the cases that I handled were in some way related to drug cases. And so, I always tried to take that prosecutorial discretion to understand, that you do have some amount of discretion when determining how to charge a case and what sort of outcome that you're requesting for the court to impose on a given case. And certainly paramount with all of that is when you're dealing with drug-addicted people or people who committed crimes while on drugs. That doesn't mean you forgive what they did, but it does mean that you do have to have a certain human touch in the way that you approach that case, and that's something that I would try to do as judge as well.
Thank you, Pat. Todd, you're next.
Thank you. This particular question is a little bit challenging because it really does border on one of the judicial canons about what we're not allowed to talk about, and that is issues that would be coming before the court and anything that could be construed as a promise. So what I will do is answer this with regards to what I've done as a defense attorney. What I've tried to do in those cases, I've tried to look at what the cause, as much as I could identify, as much as I could get a counselor or someone else in the profession to look at those issues, to identify what has led to the individuals coming in and getting into trouble with the legal system. I have then endeavored through my communication with the prosecutors and then with the judges to find resolutions that address the underlying issues instead of addressing just a punitive measure. I have found that to be a very effective means of practicing as a defense attorney, and I think that shows a little bit about how I would address these issues, or have addressed these issues, and hopefully that helps to answer your question without violating any of the judicial canons.
Thank you, William.
Thank you. This is certainly becoming an ever-increasing problem in our court system and throughout our communities because of this opiate addiction area. Something is relatively new for us. And there's, at the same time we're having increased opiate use, it seems like the state government is reducing funding for treatment programs such as health recovery services and other programs, and it's becoming a real dilemma. It's also ending up in overwhelmingly crowding up our prisons with fairly low-level, nonviolent offenders who are merely addicted to drugs and can't quit. So they get their probation revoked and get sent back because they can't quit this terrible addiction that they suffer from. As a judge, what I would do is try to work with the community leaders to develop more treatment programs, more alternate sentencing possibilities for people. I know the county prosecutor's office right now is developing some new programs for day treatment programs and day reporting programs. I would certainly encourage those uses and work with other leaders and the legislators to help refund some of these things that really are important in our society. Thank you.
Thank you. Okay, let's turn to the fifth question. Again, one from the audience in the order, Todd, William, Pat, just to make sure you're all alerted. And so here we go. How do you define justice? How will you ensure that justice prevails in your court if you get elected?
Thank you. Justice has to do with the equal application of the law to all individuals who come before the court. Part of that gets back to the understanding of what people are bringing with them, understanding them when they are communicating with you, and understanding that their language choices may be different than others who come before you, but that doesn't mean that they have a different understanding or a different ideal of what's going to happen once they get there. Taking the time to understand those issues, making sure that you hear each case and give each individual that comes before the court the time needed to make an appropriate decision, understand the facts in their case, and then make that decision for the individual situation is the application of justice within the legal system. You have to do that within the frame of what the law requires, and that provides another layer of justice in that all individuals know that they will be treated under the same law. That's very much the crux of what the judicial position requires, is understanding and applying the law with regards to the individual facts of the case.
Go ahead, William.
Well, that's a very difficult question. I believe the primary precept of justice is fairness. I think you have to demonstrate fairness to everybody involved in the legal process, the attorneys, defendants, the victims, any litigants in a civil matter as well. Fairness is a difficult concept, and one of my favorite professors in law school used to always say that if you want fairness, you have to wait till you see St. Peter. That may well be true, but we certainly all strive for that goal of fairness. So what the goal would be in justice is to allow the person, when they leave your courtroom, to believe that they were at least treated fairly. They may not agree with everything that happens. I had another judge in Cleveland that told me, domestic relations judge for a long time, said that he knew when the people left his courtroom, if anybody was smiling, he had made a big mistake. So fairness is a different concept to different people, but you have to try to give people at least the sense they were treated fairly and trying to present their whatever matter to you to decide or to assist them in reaching a resolution. So, in answer to your question, I think the most important aspect of justice is fairness. Thank you.
Thank you. Pat?
I guess in answer to that question of justice, let me tell a brief story of a case that I once had as a prosecutor, and where I had to very much face this question of what is justice in this particular case. It was a domestic violence case. I'm certainly not going to use any names or details other than to say that it was a case in which a victim had been injured fairly severely. For reasons that are myriad and complicated, the victim did not wish to take part in the prosecution of the perpetrator. And so, unfortunately, we didn't have a lot of evidence on the front end of that investigation. Without the victim's testimony, there really was very little we could do. So, she had been subpoenaed to come into court to testify. She said she doesn't want to come into court. She said, I'll leave the state if I have to. Now, as a prosecutor in that case, I looked at it and thought, well, if we want to be able to get what I thought at the time was this was a case that needed to be tried, a conviction that needed to be, we needed to strive to get that conviction. But are we going to put ourselves in the position of having to send out an arrest warrant and having this victim who's already suffered so much be arrested at her house or be arrested when she's pulled over for a traffic violation and brought into court? Ultimately, we decided that we couldn't go forward with that case, that was not justice in that particular outcome. And incidentally, that's one of the reasons that I got involved with the Domestic Violence Task Force a few years ago. It's a model for this Operations Efficiency Task Force that I'm talking about now. We brought together law enforcement, practitioners, domestic violence advocates from across the spectrum, stakeholders, and got us all to the table to say, how can we handle cases like that better to get a just outcome? Thank you.
Thank you. Okay, for the next question, the order, William, Pat, and Todd. And so what What issues are involved in deciding whether or not to admit evidence of battered women's syndrome or battered child syndrome?
What issues are involved?
Yeah, I'll read it again. What issues are involved in deciding whether or not to admit evidence of battered women's syndrome or battered child syndrome?
Well, I believe the rules of evidence are pretty clear in some of those areas. The biggest rule that would apply in that particular situation would be rule of relevancy. So the party trying to introduce that evidence would have to demonstrate to some extent, or to a large extent, that that was relevant to the matter at hand. So battered woman syndrome and battered child syndrome would generally be entered as a aspect of self-defense in those cases. I've certainly been involved in cases that involve battered woman syndrome defense. Matter of fact, one of the case I argued with the Supreme Court was involving that particular issue. You would make the judgment on whether to introduce that evidence based on whether it was relevant to the case at hand. I don't think I can answer it any more clearly than that under this circumstance.
Thank you. Pat?
I don't know that I really have much to expand on there. I think, Bill pretty well covered those bases. It's a straightforward question of relevance is the underlying standard, and so you've got to take the particular facts of a particular case and apply that standard and see what the just outcome is in that particular case.
Okay, and Todd?
That's right. This is a fairly straightforward question. It really has to do with the rules of evidence and whether or not the party that wants to introduce the evidence can show that it's properly admitted, and then whether or not that's within the rules of evidence. They frequently would need an expert witness to help with that, but it really comes down to whether or not they can meet the requirements under the rules of evidence.
Thank you. Well, here's one that comes from a different point of view, I think. So let's see the order here. Todd, Pat, William. So why should the citizens of Athens County trust that you will be a fair-minded jurist? Why should the citizens of Athens County trust that you will be a fair-minded jurist?
My history. Ask the people who have been before me. I have endeavored to make sure that everyone that comes in front of me in municipal court as an acting judge, in juvenile court as a magistrate, that they all know that they've been treated fairly. I take the time to communicate with them. I take time to make sure that I understand what their issues are. One of the stories that I mentioned while I was at the Democratic dinner was about someone who came into juvenile court who was asking for custody and asking for parenting time. And after hearing the evidence, after many, many hearings, including a final hearing where they introduced their witnesses, I did not award custody to him. I granted custody to the mother of the child, and I gave him relatively limited parenting time. And he stopped on the way out, and he said thank you. And that doesn't happen very often when people don't get what they want. And he expounded on that. He said, thank you for taking the time to understand what was important in this case. For taking the time to really communicate with us. You are the best judge that I've ever been in front of. And I did not give him what he wanted.
Thank you. And next, Pat?
I think that listening is one of the most important aspects in a lot of arenas of life, but certainly in judges, and I know that I've been before, as I'm sure that the other two gentlemen up here have, in front of judges who are good listeners and ask good questions, and those that just kind of barrel right through without really giving anyone a fair hearing, be that attorneys or the litigants themselves. One of the things that I'm proud of in my time at the City of Athens as law director is that I have always tried to make that a very important part of what I do, whatever the issue is to listen. And I'll give you a quick example. When I first came into office, the city had a long-running, very, very long-running history of litigation with the Environmental Protection Agency involving some issues that involved paint at a drain well back in the late 1980s. And this case was still going on when I came into office in the mid-2000s. And one of the first things that we did upon coming in and realizing that they were talking about the potential of $5 million fines like that, is the first thing I said as well, who have we talked to, who's been our point person on the city in dealing with this, and was basically told, well, they've stopped talking to us. They've the previous, I don't want to name any names here or anything, but no one has really been in communication, so we're going to hit you with this fine. One of the first things that we did, myself and a deputy auditor, we got on a plane to Chicago, sat across the table from the folks at the EPA and said, what is the problem? And long story short, because I don't want to run over on time here, we heard them out. we listened to what the issues were, and we found a way to address them in a way that led to a settlement which was much more fair for the taxpayers than some of the numbers that were getting thrown around when I came in. I would try to do that same thing as judge.
Thank you. William?
I believe you just have to look at the past history of the candidates, and I think you would see that from my 29 years of experience that I've been fair with my clients, I've been fair with the court system, I've tried to be fair with other elected officials and fair with everybody. I don't think there's anybody that would say that I haven't been a fair person in my dealings with them from a legal perspective or personal perspective for that matter. How can I prove that to you today is a virtually impossibility. All I can do is say that I would be fair as a jurist in this county. Thank you.
Thank you. And the order for our next question, Pat William Todd, and here is that question. Do you believe there is underrepresentation of women in the court system?
That's probably a little above my pay grade in terms of being able to say the entire court system. I can say that certainly here in Athens County, I can tell you in my office, which of course is not an outlet of the court system per se, but is certainly part of the apparatus of trying to seek justice, having 3 full-time prosecutors. I'm proud to say 2 of my 3 prosecutors are women. Both of my other administrative staff in the in my office are also women. I can tell you that from my dealings with the court, in the Common Pleas Court specifically, that certainly there is we have a county clerk of courts who is a woman and does a fantastic job, and there are certainly a number of other employees over there as well. So I don't know if that really answers the question. I don't know that I'm qualified to necessarily answer that question, seeing as how I'm obviously not being able to have that firsthand perspective. But I guess that's probably about as close as I'm going to be able to come to answering that one. Thanks.
Thank you. William?
Was the question about the legal system in general, or the court system in particular?
Let me read it. It says, do you believe there is underrepresentation of women in the court system?
Well, I'm not sure exactly what that means. I think as I look back at my history as an attorney, there was a lot less women involved in the legal profession back in the 80s than there is in the 2000s. I can tell you that. And I think it's a great change for the better. We didn't have a lot of women prosecutors back a while ago. There are a lot of women prosecutors now. I think there's a majority of the prosecutors in the prosecutor's office are women now. I mean, I'm not sure there's underrepresentation anymore in the court system than there is elsewhere in society. And I think it's the same as I was saying in my opening remarks about discrimination against people that have disabilities. It's better now than it was back in the 70s, but we still have a long way to go to make things really equal across the board. Thank you.
Thank you. Todd?
Thank you. Within our local legal community, we have a wide range with regards to gender. Well, it's a range of 2, but we have a pretty good amount of diversity. There are a lot of men and a lot of women in roles throughout the system, and we have, as has already been addressed, quite a few of the prosecutors in town are women. There are also men in the role. Quite a few of the private practitioners in town are women. Quite a few of them are men. This particular issue is one that I'm happy to say is not a very real issue within our local bar association. Within the leadership roles, current president is female, current vice president is female, and it's been back and forth, not in a straight line. There's no structure to it, and there shouldn't be. It has to do with who's available, who can do the job, and I like that about our system. It's not about gender when people are asked to be in these positions to do these roles.
Thank you. Well, I think we're ready to turn to another question, and so the order on this one, William, Todd, Pat. And if elected, what will you do to improve the operation of the court and expedite its resolution of cases? How would you improve court processes? Would you review and revise the court's local rules?
Well, I'm sure that anybody that took office would want to review the local rules and possibly would make revisions. One of the things that I would really like to see happen with a local court is same-day transcripts in the court system. This was available back in the 1990s when I watched the O.J. Simpson trial on TV. They had it back then in Los Angeles. Now the technology is certainly available that we should be able to have same-day transcripts. This would greatly improve the procedures in the courthouse and make attorneys more prepared the following subsequent days, and also as cases get continued perhaps a month later to refresh their recollection as to what might have happened at prior court hearings. I also think the technology in general has been slowly improving in our courthouse, but I think there can be also more done to improve the docket control system and also to make documents available online for litigants as well as attorneys. The PACER system has been available in the federal court system now for over a decade. Very low cost to obtain actual copies of documents that are filed with the court. As a matter of fact, all filing in federal court now has to be done electronically. They don't even take paper anymore. This would not only be a boon for attorneys, but it would be ecological positive step as well. So those things are two of the things that I think are really important and we need to look at right away. The local rules, they're very lengthy. It's hard to say what I would want to change in local rules, but I doubt much at this point. Thank you.
Thank you. Todd?
So there are quite extensive local rules in place. They are not always required to be followed. They are not always held to a very high standard as far as what the enforcement is on any given case. That is in part because of the need to make sure that in any given case that you consider not just the rule that's in place, but whether or not there are reasons to allow deviation from that rule for the purposes of justice. What I think the answer to the question, though, really comes down to making sure that the rules in place are able to be administered fairly, that they are written in such a way that they can be consistently applied without too much need for deviation. I think that they do need to be reviewed. They do need to be consistently applied as much as possible. Part of that also means that the two judges we have, whoever wins from this particular group, will also need to work with the other judge that wins in November. And that communication will need to be something that works on an ongoing basis to make sure that the rules in place are the ones that both judges are comfortable with and that they're able to enforce it effectively. All of this still requires, in the individual case, that the judge applying the rules hears the issues that are coming in, and if there is a need for allowance of an extension of time or for other options to be considered that are outside of the rules, that is allowed when it is appropriate, but that's a case-by-case issue.
Thank you. Pat?
Yes, thank you. I think there are absolutely some areas where we can increase our efficiency in the administration. I'll give you a couple ideas here have been mentioned. I'll throw out one more. Is just the just a very simple idea of paper. And the fact that we live, obviously, in an internet age where it's not necessary to have everything on a piece of paper. It's Earth Day today, so in honor of the environment, I think that's one area that we can look at. And now, some of that you're going to be constrained because, again, rules of the Supreme Court, rules of that you really don't have the discretion to change with your local rules. But I'll give you an example. The federal court system is outstanding when it comes to this. They figured this out years ago about all of the pleadings being done, everything being submitted electronically, filed electronically. You don't have to print out 50 pounds of paper and mail it to the courthouse in Columbus. So I would like to see us be able to take some steps in that direction, again, understanding what discretion we have and don't have. I think it's why we need to have an operations efficiency task force that brings people together from across the spectrum. I have a history of building consensus, of listening, of asking questions and bringing together the relevant stakeholders. I've talked to the prosecutor about this idea. I've talked to former judges about this idea to a person. They are excited about this idea, and I think it's one that just has all kinds of potential for us to be able to get people from different perspectives, to look at the local rules, to look at some things that we can be doing more efficiently, and to be asking the right kinds of questions. And I want to say I certainly don't claim any ownership over this idea. If one of these other gentlemen up here should win, and I certainly hope that they will consider stealing that idea because I think it's fantastic regardless of who wins. Thank you.
Thank you. Well, for our next question, the order is Pat, Todd, William, and here we are. If elected, what metrics would you use to measure your progress and performance?
It's a really good question. We've touched on some of the things here, just about, at least on the efficiency side, from the court operations side. I want to have this task force in place. I want to report within 6 months. That's going to have some very measurable things, in that report that we can look at and see, are we making progress, and to have a measuring stick moving forward from that date. I'll give you one example of, again, where I think listening, consensus building can come into play and in a way that is a measurable outcome. And that is in my work with the City of Athens. I'm very proud to say that we are involved in much less civil litigation than we were when I came into office at the end of 2007. And every year we have to file paperwork with the auditors about all of the litigation that the city is involved in. I'm proud to say that number has gone down almost every year, to the point to where I think we're down to 3 or 4 cases in our last one, which is a substantial reduction of where we had been. And again, there's no great secret to this, and I certainly don't take all the credit for doing that, but I do think that one of the major steps to getting the city's legal affairs in order and getting them to that point was that, under the leadership of the current administration, certainly in the city and the council, that we've tried to identify problems before they become bigger problems, before they become a lawsuit. Let's get the relevant stakeholders to the table. Let's try to get as many perspectives as we can and try to use a little bit of preventative approach here. And that's something that's worked very well, and that's certainly something that I would continue to try to do as judge.
Thank you, Pat. Todd?
So there are some pretty good numbers that are recorded with regards to the types of cases and numbers, and with regards to how those are resolved. Those can all be reviewed, and I think that those do give you some feedback. In the end, though, I don't think it's really about numbers, and I think it's about people. I choose to be in a local court system doing trial court work because I like to work with people. I think at the end of the day, that's also how I measure my success, is whether or not the people that are leaving the courtroom walk out, not necessarily getting what they want, but again, feeling valued, knowing that they've been heard, and that they are going to walk out knowing that it was a fair system that treated them appropriately. That's how I value things.
Thank you. William?
Thank you, Ellsworth. The Supreme Court has issued rules of superintendents regarding the court system in Ohio, and they set guidelines on cases, how long cases should remain active, and how long motions should remain before they get resolved, how long other orders should be issued. And I think one would strive to reach those kind of guidelines. They are merely guidelines and can be extended. If they're extended, then the court has to notify the Supreme Court about why they took longer than they were supposed to resolve a particular matter or to respond to a particular motion or whatever. All of these numbers are available on the Supreme Court website in the Supreme Court reports that are issued annually talking about the state of the judiciary in Ohio. So that would be certainly a guideline to follow and watch and a metric to follow. I don't know how you would really be able to tell much about how the litigants felt when they were leaving, because my experience is judges don't really talk to litigants too often personally. You might be able to get some feedback from the attorneys at some point in time, but it's rare. It's almost unethical at times for lawyers or judges to talk to litigants as they're leaving the court. So I think the main way to measure would be how you're getting the cases processed in a timely fashion. Thank you.
Thank you. Okay, for our next question, the order, Todd, William, Pat, and how do you rate Athens County's use of mediation in our courts compared to other courts in the state? Are there changes you would make as judge related to mediation?
Athens County doesn't use nearly as much mediation as many other jurisdictions will use. And it's something that we have tried with various mediators, and we've had varied levels of success while using it. First of all, it's a very good option when it works. There are some downsides to it. If you have a requirement that, let's say in a divorce case, that mediation is going to be explored, it takes a lot of time. And we've already been talking about the need to get cases resolved in a timely manner. It is not uncommon that it will take many, many months for them to go through the mediation process. And if there is no consensus, no full agreement at the end of that, then you don't have anything tangible. Hopefully they have some small levels of agreement that they reach, but in the end, most of the cases that I've seen end up where they don't get something tangible that they can use from that mediation. I would like to use it more. I would like to see more effective use of it in the cases that we have. I would be interested in meeting with others who've had better success and find out more about what they have used that's been effective so that we can try to implement that within Athens County. But I will balance all of that with the other needs of the court, including the time requirements that come in.
Thank you. William?
Thank you. I don't have a great deal of experience in other counties' mediation. Mediation ordered by the courts is a fairly new process. The Supreme Court several years ago made a big push under Chief Justice Moyer to encourage mediation in our local courts. And for a while, there were grants available for the court to pay mediators, and I think for that period of time, that couple of years or 3 years period, whatever it was, we utilized mediators a lot in Athens County, especially in domestic relations matters, where people really need to sit down and look at the issues and look at what affects their children and try to resolve those issues without the judge dictating to them what they have to do. I think we need more mediation. In 1991, I was involved in helping establish the Athens Area Mediation Service. I think it's a valuable resource. It's underutilized, like many resources. However, it is utilized, and I think it does avoid costly litigation by helping resolve problems, helping people resolve their own problems with one another, rather than having the results dictated to them. So I would certainly do what I could do to increase mediation in the court system. However, funding is, again, always a problem with these types of things, because no mediator can afford to work for nothing. And litigants are often paying their attorney as well and can't afford to pay the mediation. So we need to look at possible alternatives to paid mediators. Thanks.
Thank you, William. And Pat, you're next.
I've had some experience in mediation, and honestly I found it to be a bit of a mixed bag. I think it does make sense for certain kinds of cases. And I think overall, I think the idea of mediation and of sort of alternative dispute resolution is a very exciting one. I think that if you can ever have a situation in which folks are on a litigation track, it's sort of like what I was talking about with what we've done in the city of Athens, and you can find a way to get off that track, and you can find a way to reach some sort of agreement that both sides can live with, even if they're not terribly happy with it. But as long as you've got an agreement, then you've got, two parties or however many parties at the end of the day who are going to take more ownership of that, as opposed to just a decree being handed down from a court which says one side wins and one side loses. That said, you're going to have a lot of cases where that's just not going to be a feasible outcome. I think this is a very good example of where having an efficiency task force that can look at questions exactly like this and determine what are the sorts of cases where we seem to be able to get some good outcomes, versus what are the cases that we put into mediation and no one can agree on anything, and all we do is drag this thing out another 6 months. I think that would be a very good specific idea that could be looked into. But as a concept, I'm very excited about it and think it's got a lot of potential.
Thank you. I think we probably have time for about one more question, and the order, William, Pat, and Todd. And so this one, at least to the layman, sounds sort of complex. Let me read it twice, because it's fairly long. So I'll read it twice, and then we'll turn to William. The Supreme Court is responsible for oversight of county courts. Rule 37 of the Rules of Superintendents for the Courts of Ohio mandates periodic reporting on the court's progress. Will you ensure the Athens County Court of Common Pleas complies with the requirement for accurate and timely submissions to provide the Supreme Court with an accurate understanding of the operation of the Athens County Court of Common Pleas? Will you make these reports available to the public? And thirdly, will you review Athens County's metrics in comparison with other counties and solicit input and or work toward publishing an annual report detailing the court's current challenges, areas for improvement, and planned actions to improve the court's outcomes? For us laymen, it's a tough one. So for us laymen and laywomen, if I dare abuse the language, why, we will read it again so that all of us can listen, and you're welcome to too. So, the Supreme Court is responsible for oversight of county courts. Rule 37 of the Rules of Superintendents for the Courts of Ohio mandates periodic reporting of the court's progress. Will you ensure the Athens County Court of Common Pleas complies with the requirement for accurate and timely submissions to provide the Supreme Court with an accurate understanding of the operation of the Athens County Court of Common Pleas? Will you make these reports available to the public? And will you review Athens County's metrics in comparison with other counties and solicit input and or work toward publishing an annual report detailing the court's current challenges, areas for improvement, and planned actions to improve the court's outcomes? Okay, William.
How come I always get the hardest questions? That's unfair. I think I touched on this a few minutes ago. The Supreme Court reports is published annually by the Supreme Court. When I was prosecuting attorney, I'm quite confident that the court submitted their monthly reports to the Supreme Court, that document how many cases have been resolved, how many cases are overtime, and I'm confident they still do that. I haven't seen those reports in a number of years because I've had no interest in reviewing that kind of statistics. But I think they are available, and I think they are available on the Supreme Court website if you go and look for Supreme Court reports. And every county is listed as to how they are fulfilling the obligations under the rule. Now, I'm not sure what Rule 37 of the Rules of Superintendents says, because I haven't memorized or even already looked at the Rules of Superintendents. So I'm assuming that's the rule that says that the court has to report on a monthly basis. There's a worksheet that the Supreme Court provides that you fill out and document how many cases you have that are untimely, how many cases are overtime. You have certain obligations to resolve, for instance, criminal matters within 6 months. You have to report how many are overtime and why they're overtime, if they're overtime. I think those reports are provided already, and I would certainly ensure that they continue to be provided, and that I would ensure they're done accurately and timely. Thank you.
Thank you. And Pat, you're next.
I'm going to go out on a limb and guess that that question was either asked by an attorney or a very committed layperson. That was, kind of echoing Bill's sentiment on that. I'm not going to comment with any specificity on Rule 37. I certainly I'm not familiar with that off the top of my head, and I'm not going to commit myself or commit the court to potentially doing or not doing a certain thing based on that. I will say that we'll obviously comply with the requirements of the rules. And as to the part of the question dealing with metrics, I think I'm a big believer in measurables and in being able, and sometimes, you know, it's harder than other times. But I'm a big believer in trying to find ways to be able to assign numbers and to use math and to be able to chart specific progress or to identify new areas of concern. And so to the extent that we can use those numbers to compare Athens County against other counties within the region, or Athens County against other similarly situated or similarly sized counties around the state, I'm all for that.
Thank you. Todd?
So yes, I will ensure that compliance with the Supreme Court rules will be followed. This is something we do already in juvenile court, as we're all required to do. There are cases that are past the guidelines in every court, in juvenile court included. Part of that is what we've referenced before. I have to make decisions in juvenile court, just like I would as a common police court judge, about whether or not the facts of any given case require that, in the interest of justice and fairness, there be extensions granted under the right circumstances. This does mean that some cases go longer. That being said, timing is important. Timing also matters to the litigants, especially when people are coming into the court system. Attorneys, frankly, get used to it. They are used to having extensions and continuances granted. But a little bit more understanding about what is happening and why is important, and spending the time talking with the individuals who are in court through the court process and making it clear to them that there will be limited continuances as appropriate is a good practice. I do this in juvenile court. I do it on the record. I make sure that they know what the reasons are going to be if there is going to be a continuance, and when there is not an appropriate reason for that continuance or for that extension, I deny it. And I will make them stay and do the hearing. I do this even if it means I stay late, even if it means that I don't get to go home and have dinner with the family, because it's important to resolve those cases, give them a resolution so that their life can proceed as well.
Thank you. Well, it's roughly 7:40, and the library closes at 8 o'clock. And one of the things, we envision having these candidates nights on into the remote future, so we do not want to wear out our welcome. So no more questions. We'll head into closing statements and so on, and because we want to be able to leave in a timely fashion. And the order, these will be 2-minute closing statements, and the order of those was also determined by lot beforehand. And since you men may or not have it in front of you, it's William, Todd, and Pat in that order. I see you've got it. Very good. And we'll also note, thanks to Ed Baum, you've got that. And Ed, I think Ed Baum is probably the only one who wasn't praised and lauded and whatnot. He's the one who takes charge of these, sets them up. May we have a round of applause for Ed Baum? He may shoot me for that if you ever see me again. Why? That's the way it goes. But it was worth the sacrifice. All right. And so for the closing statement, 2 minutes, William Biddlestone.
Thank you, Ellsworth. Judges must apply the law fairly, impartially, and competently. I remind you of this again because I believe that based on my legal and life experiences, I am the most qualified candidate for judge. Of the 3 candidates running for election for this judgeship, I have the most legal experience. I also have a wealth of human interactions and life experiences to draw on to help me make the difficult decisions judges must make. My 29 years of legal experience is broad and widespread, both in the public and private sectors, criminal and civil arenas. I have tried more than 40 cases to juries. I have argued cases in the courts of appeals and in the Ohio Supreme Court. Neither of my opponents' legal experience compares to mine. I have strong connections to the community through my work on the boards of the Athens County Board of Elections, the Athens chapter of the American Red Cross, United Seniors of Athens County. I helped found the Athens Area Mediation Service to provide low-cost dispute resolution alternatives to costly litigation. Before being admitted to the Ohio Bar in 1984, and while I attended law school, I was a social worker in Cleveland helping disadvantaged and disabled persons overcome obstacles as they sought to better their lives. I'm fortunate to be the parent of 2 wonderful children who are now Ohio University graduates and pursuing postgraduate degrees. All these legal and life experiences will help guide me in making the tough decisions a judge must make. To me, the fundamental element of judging is fairness. When a person leaves the courtroom after the stressful ordeal of a trial, knowing that they were treated fairly throughout, that is the hallmark of justice. I will look to my legal and life experiences to be fair and just in all matters that come before me. That, after all, is all we can rely on as human beings, and that is my pledge to you. Thank you for your attention, and I ask you to vote for experience on May 6th. Vote for Biddlestone.
Thank you. Todd Grace?
Thank you, everyone, for coming out this evening and taking the time to hear from us. I've talked a lot about my experience as a jurist in both juvenile court and in municipal court. What I'd like to do right now is draw attention to the reason why I have that experience. This is a very clear distinction between myself and both of my opponents. I have that experience because I've made a dedication to the legal community in Athens to be part of the legal system as a jurist. 11 years as a magistrate. That meant that I was working within that system for that entire time because I knew that I wanted to get the experience so that I would be able to be the best judge I can be. It doesn't pay very well. I did not do it for money. I did it for the experience. I found that I enjoyed it. I found that I was good at it, even though it was hard, and even though I went home some nights very tired and unable to really come back and say, yes, in the end, this particular case has a resolution that everyone could enjoy. That just doesn't happen. But I made sure that everybody knew they were heard. I made sure that they were valued while they were in the system. I am dedicated to being part of the local judicial experience. I want to stay in Athens County. This is where my family lives. We have 4 wonderful children. I want to stay here. I do not look at this as a career advancement to move on to something else. I want to stay in the trial court of Athens County. I would stay here for as long as I could. I don't look at this as something to move towards appellate court. I don't look at this as something to move in another direction as a career path. This is a career goal for me, is to be a judge, and to be a judge at the trial court level. I hope everyone wants to have a person dedicated to the judiciary, dedicated to being part of Athens County for a long time in this role, and I know that I have something to offer in that role. I hope you vote for me.
Thank you, Todd. Pat Lang?
You know, so often in these election campaigns, including judicial campaigns, you know, the candidates will attempt to frame an issue in the way that sort of best suits our strongest arguments. And I certainly do this too. I'm not immune to that. And I think to some degree we've seen that on the question of experience, especially. I think we have candidates who are framing the question of what is experience and what is the most relevant kind of experience in different ways. I'm certainly very proud to be in my 7th year as the law director for the city of Athens, where I'm managing and overseeing a full-time staff of attorneys who are in court every day. As an assistant prosecutor for the county, I was in court every single day. I've had that part of the experience of being a courtroom attorney. I've been in private practice, worked in a number of different areas of the law, so I certainly don't take a back seat to anyone when it comes to the question of experience, and I won't single out either of my opponents other than to say, as I did in my opening, that I think they're both very good attorneys and they would both make very good judges. But you know what? At the end of the day, it's really not about, certainly not about me, and it's not about the candidates that you see sitting up here in front of the room. It's about Athens County, the people of Athens County, and the sort of direction we want to take our judiciary in the next 25 to 30 years. And the sort of person, or the specific, in this case, the specific candidate, that we believe is best suited for that task, for that leadership role. And you know, I would be honored. I've talked a lot about conversations tonight, a lot about listening, a lot about reaching out. I would be honored to help lead that conversation. I would be honored to serve as your judge, and I would be honored to have your vote. Thank you.
Thank you. Well, one little round of thanks, and I want to thank the candidates for coming. Evan Smith of the Athens News and Susan Tebben of the Athens Messenger, thank you very much. And next week there's going to be another candidates night, same time, same station, so to speak, here at 6:30, and it will be for the Republican candidates for the 94th State House District, Yolande Dennis and Daniel Lance. And I have one more big thanks I want you to join me on. Todd Bastine, will you stand up? I was hoping you'd be against the wall. Thank you, Todd. Todd is the one, what should one say? The library and the League of Women Voters together do this. And Todd is the foundation's, no, that's not, I need the strong man of the staff who, thank you very much, Todd. Next time I'll practice that a little bit better. Okay, thanks everybody for coming, and see you next week.